So today we're going to be talking about employee handbooks and how to remain compliant with the most important document that you need to have. So why employee handbooks? You need to make sure employees know what is and is not allowed, how to behave, and maintain harmony in your workplace. Let employees know what will lead to discipline so they can avoid it. If you terminate someone for what you believe is a policy violation, but they believe is discriminatory, it's difficult for you to tell a jury, we terminated him because he broke a rule, he knew he would be terminated, if you don't have a handbook or if your handbook is bloated and overstuffed with non-legal information. To show that the former employee knew that what he did could lead to termination. If the employee can show that no one ever told him not to do what you terminated him for, it looks like the termination was pretextual, that you made it up as an excuse for a discriminatory termination. Many states require you to inform employees of time and place of employment, length of pay period, paid sick leave, paid family leave. FMLA are all required to be in your handbook, or you could be fined or sued for not having them. Many states require a harassment and discrimination policy, and you can't comply with the policy if you don't lay out the complaint process in the handbook. So laying out that complaint process for harassment and discrimination is legally required. So state and federal laws are changing all the time. Many laws become effective on January 1st or July 1st, so you should have a licensed attorney who is aware of all these changes, keeping you up to date at least annually. Most states will not give you leeway when it comes to providing notice of a law change. So you may be able to distribute a standalone policy at the time of the law change, but the law change should be permanently in your handbook then within the year. Traditional law firms charge by the hour to draft employee handbooks. This will run you into the thousands of dollars. An AskHR best practices handbook with state supplements for all the states in which you operate is included and updated annually with your AskHR subscription at no extra charge. Our handbooks are drafted by licensed attorneys and do not contain any disclaimers to make sure they're compliant from year to year. So what are the handbook mistakes employers make? Public college and university handbooks are easily available online. They seem very, very professional, but many public employers are covered by a collective bargaining argument, which is going to cause problems if you adopt that handbook. Also, these usually operate in one state. If you operate in 12 different states, you're left totally uncovered and non-compliant without your state-specific handbook. Mistake number 2, make sure employees know what they don't have to put up with. If your jurisdiction has a Crown Act, put natural hairstyles in your list of protected classes. The Pregnant Workers Fairness Act is a new one, new specific language that needs to be put in the handbook. And handbook mistake number 3, some employers think that having every possible legal and non-legal rule and bit of information will help them when it can actually hurt. A former employee may be asked in court, well, did you read the handbook? And if they pull out your 400-page handbook and say, well, how was I supposed to read and keep track of this? A jury may find that your former employee did not know that he was breaking a rule. Things like where to park, how to answer the phone, birthday, wedding, baby showers, what to wear on spirit days, all that needs to be kept in a training manual and not your handbook. So handbook mistake number 4, if you, some employers believe that they do not have to comply with the National Labor Relations Act if they are not a union shop. That is not true. The National Labor Relations Act covers all employers. And after the Stericycle decision by the NLRB, which we have discussed in previous webinars and have information on our website, after that, things you do may be considered unfair labor practices. that can be brought to the NLRB even if your workers are not covered by a CBA. So you have to make sure that your handbook is compliant with this most recent decision. Handbook mistake number 5, at-will employment. If you forget to add an at-will disclaimer, at-will employment should have its own policy. It should be added to, the statement should be added to a lot of your policies. One of the big ones I see is probationary period. If you, I don't like probationary periods, but if you must have one, you need to make sure that it states at-will employment in that probationary period paragraph, because you need to make sure that employees don't think that they are guaranteed employment for 90 days or that completion of the 90-day period means they're permanently employed. So if you have that provision, you need to include an at-will disclaimer in that. The definitions of full-time, part-time, exempt, non-exempt, those also need to have an at-will disclaimer. You don't want an employee to think that just because they have full-time status, that means they cannot be terminated. Handbook mistake number 6. This is insufficient harassment and discrimination policies. Like I said, the Stericycle most recent NLRB description has requirements for your harassment and discrimination policies. A lot of handbooks are adding workplace bullying. It's not harassment or discrimination based on protected class status, but that's something complementary that you can have in your handbook. Also, diversity, equity, and inclusion, or DEI policies. They establish that your company is committed to all backgrounds, supporting all backgrounds and cultures, and they set out expectations for employee behavior with regard to DEI, including refraining from discrimination and harassment. Handbook mistake number 7, having a having a progressive discipline policy that is too rigid. Your discipline policy, again, with at-will employment, should state that you have the right to skip steps in your progressive discipline policy, that no action needs to be taken before termination occurs. If you promise your employees that the order goes verbal warning, written warning, suspension, termination, and does not give you the right to skip steps, you may be stuck with an employee who engaged in gross misconduct and having to give them a written warning and let them keep working. Handbook mistake number 8, failing to get a signed acknowledgement. The signed acknowledgement is not a contract. The only recourse you have for almost all policy violations is termination. And if you are subject to a lawsuit or claim, this signed acknowledgement is absolutely necessary to show that the employee knew the rule and that you did not terminate based on an illegal reason and make up an unknown policy later. The acknowledgement shows that the employee did know that what they did was prohibited and that was a non-discriminatory reason for termination. Handbook mistake number 9. Now, when we say not to overstuff your handbook, some policies are required by law, and leaving these out could get you fined. A big one is paid sick leave. Even if you have a policy where paid sick leave is covered, encompassed in your PTO policy, you still need to have the paid sick leave policy in your handbook because you need to inform your employees of their rights under paid sick leave. So you can put a statement that says, all paid sick leave is covered by our PTO policy and employees are not entitled to any additional leave, but you still have to have the paid sick leave policy in there to make sure that you are complying with state or local statutes. and that you are notifying employees of what they need to be notified of. Handbook mistake number 10, failing to definitively state what happens to accrued but unused PTO or vacation on separation. So some states do require you to pay out unused PTO or vacation no matter what. In most other states, the handbook controls what is to be done upon separation. If you want forfeiture, you have to put it in the handbook. Most states, if you don't have a forfeiture clause, if you don't say that it won't be paid out, then the state will make you pay it out. Other PTO and vacation policies are covered by law and must be compliant in your handbook. That includes things like whether or not there is carryover from year to year, whether or not you have a maximum accrual cap. So a big handbook mistake number 10, I saved the best for last because what I really see employers doing wrong in their employee handbook is that the PTO and vacation policy being non-compliant. And when with our handbooks, the Ask HR Best Practices handbook that is included with your Ask HR subscription at no extra charge, we do customize your PTO or vacation policy and include that in the handbook, again, at no extra charge. But we make sure that if you want to forfeit paid leave, that's in the handbook, and so employees know that they will not be paid out their PTO. We make sure if you are going to encompass paid sick leave within your PTO or vacation policy, we make sure that your PTO or vacation policy is generous enough to comply with all of the state laws and rules and regulations and city rules and regulations. We look at your policy and make sure it's compliant, because sometimes I see things like PTO must be used in minimum increments of 4 hours. Well, if you look at the paid sick leave law, it says you can require increments of no more than 1 hour. So even if your vacation is or your paid sick leave is covered under your PTO vacation policy, if you're going to do that, you have to make sure that you then change your PTO or vacation policy to be increments of 1 hour so that you're complying with those paid sick leave laws. So that was a very quick take through employee handbook mistakes. It is important to have your handbook updated annually by a licensed attorney. And like I said, it is included with your Ask HR subscription, but don't sit on that document. Get that updated annually. Get that updated when laws change, like the National Labor Relations Board Stericycle decision. I'm sure there are things in your handbook that can't be there anymore. So please open up a ticket, and we will get started on our best practices handbook for you, along with supplements for all the states in which you operate. So thank you all for participating in the webinar today. Like I said, if you have any questions about handbooks, please open a ticket in the Ask Our Attorney portal. If you are not a client and you would like to know how an employee handbook can help your company, please email info@myHRcounsel.com. So thank you for joining us today, and I hope you all have a nice rest of your day.